Hey, Paul Rabelais here, estate planning attorney, here to address 5 biggest mistakes people make when they attempt to get their estate legal affairs in order. A lot of mistakes being made out there. Nobody's perfect, but I'm going to go over with you the 5 kind of biggest mistakes that we see. There's a bunch more. So let's jump right in. First biggest mistake that we see people make is not addressing the long-term care component when they're putting their estate legal affairs in order. It's the, what if I get sick, I have to go into a nursing home or a skilled facility, I'm going to wind up losing all of my money and I'll lose my house when I pass away. How to avoid that? Problem is, many people, they go to a lawyer because they're told and they've read that they need to get a will. So they go see a lawyer and they go with this specific intention of getting a will done. And nobody ever brings up this long-term care component. The problem with not bringing it up is if you don't address it, then you may not be left with an estate to distribute when you pass away, because our Medicaid laws require that if you go into a nursing home, you've got to spend all your money down to $2,000. They'll let you keep your home, but just in case you get well enough to go back home. But when you pass away after having spent all of your own money, Medicaid will have its estate recovery rights on your home, so that your home has to be sold to pay Medicaid back for what it spent on your nursing home care after you spent all of your own money first. So addressing long-term care is an important component of getting your estate legal affairs in order. Not everybody really has to address that. Some people have it covered who have really good long-term care insurance products. Other people have significant wealth and resources and income, so that if they do need that care, and they do incur a many thousands of dollars of cost a month, it's not going to put a dent and they're not going to deplete their estate. But middle class America, something they really got to deal with, because you risk losing everything. So number 1, address long-term care. Number 2 is a mistake of not addressing taxes. I'll be the first to admit that most people don't have to worry these days about their survivors having to incur federal estate tax, because the way the law is in effect now, somebody dies, if they have less than $11.2 million worth of assets, there's not going to be any estate tax. Married couples, $22.4 million. Almost no one has to incur estate tax consequences, but there's other tax aspects to estate planning. There's the capital gains tax. And so lots of decisions have to be made when you're putting your legal affairs in order about the best way to transition assets that you have to the next generation, because if the next generation or the one after that sells those assets, there's going to be some capital gains tax consequences. And so we want to take a look at the step up in basis, the double step up in basis. You know, just a quick note, years ago, it was really forbidden for the first spouse to die to just leave everything and lump everything into the estate of the surviving spouse. But because that caused the surviving spouse's estate to be too large for estate tax purposes, for most families that worry has been eliminated. So now what was forbidden is now encouraged, in order so that the entire marital assets gets stepped up twice. Once when the first spouse dies, once again when the surviving spouse dies. So there's lots of capital gains tax issues that need to be addressed when putting your legal affairs in order. And then there's, of course, income tax consequences. For many, their largest financial asset is their traditional IRA, perhaps their 401k. Most people know that distributions from that are subject to income tax. And so there's lots of strategies there on who do you name as your beneficiaries of your traditional IRA or your 401k. Should it be your spouse? And there's a specific set of rules that apply to distributions to a spouse. Should it be your children? Should it be your grandchildren? We've seen some people take advantage of prolonged distribution rules when they leave IRA assets to people that young. Some people who have charitable interests, they'll elect to make sure that charitable bequest is satisfied out of their IRA, because the charity doesn't pay any income tax on those distributions. So lots of income tax consequences. Got to make that part of your overall estate planning program. That's mistake number 2. Mistake number 3 is not addressing probate. Kind of like problem number 1. Paul, we went to a lawyer to get our will done. We got a will done. Nobody brought up the fact that we could avoid all this attorney involvement upon a death, avoid the 2 court processes when each spouse passes away. So the conversation at least needs to be had. I think a lot of attorneys won't initiate that discussion because they're kind of comfortable doing the wills and then really handling the more lucrative court-supervised probate process when the person that they prepared the will for passes away. But it really is a conversation that needs to take place because just about everybody perceives this court-supervised process as being too long and being too expensive. So that conversation needs to take place. That's mistake number 3. Mistake number 4 is working with the wrong people. Occasionally, I've seen people, because they watch TV, read the newspaper, they see the large financial institutions, the brokerage firms, they offer estate planning as one of the things that they do, and they wind up going to that financial institutions to get their estate planning done, and they leave with a large life insurance policy. So really, buying life insurance is so far removed from having a comprehensive estate legal program in order. So you want to make sure it starts with an attorney, but not just any attorney. Maybe you had a personal injury settlement and you received some money and you wanted to make sure you got your will done. You went back to that attorney. And so that's not the right thing to do because they're good at handling, personal injury claims and not addressing all these things that often get overlooked. We've seen a lot of people come into our office and say, Paul, we went to an attorney, but boy, that attorney just talked and talked and talked. They didn't even listen to what we wanted or what we had to say. And the words that they used when they spoke with us were over our head. And so not only do you need to work with an attorney, but you need to work with the right one who listens, asks you the right questions, speaks in terms that you can understand, somebody you're comfortable with. So working with the wrong person is another mistake when it comes to estate planning. That's our 4th mistake. Our 5th and final mistake is not covering the reasonable contingencies that you need to address. Can't cover them all. Can't cover if me and my entire family, all the way down to my 4th cousins, are all on an airplane together and the plane goes down. Can't really address every contingency, but you ought to address the basic ones, like what if my spouse predeceases me? Seen a lot of people on their life insurance, annuity, their beneficiary designations, their IRAs, their Roths, their 401ks. They name their spouse as their beneficiary. They want things to go to their spouse, but they don't designate the secondary or contingent beneficiaries. Spouse predeceases, then the account owner dies, and now you're subject to the terms of the contract, which will dictate where those assets go, and it may cause unintended consequences. So you can't, like I said, you can't cover every possible contingency, but certainly the reasonable ones. What if my spouse predeceases? We often address what if a child predeceases. Doesn't happen often, but we all know it happens from time to time. Then there's other contingencies. What if my children get divorced? I want to make sure that what I leave my children is for my children only, even if they get divorced. I don't want anything going to their or my ex-son-in-law or daughter-in-law or my step-grandchildren, whatever the case may be. So there's a few reasonable contingencies that should be addressed as part of an overall, estate plan to make sure everything's in order. So there you have it, the 5 biggest mistakes. Number 1, not addressing long-term care. Number 2, not addressing taxes. Number 3, not addressing probate. Number 4, working with the wrong person. And number 5, not covering reasonable contingencies. I could go on. I could probably make a list of 20, probably will one time, but I wanted to give you those 5 to start with. If you address all of those 5, you'll probably be starting off on the right foot. Make sure that you get things done ahead of time. Work with the right people. So important to get it right the first time. Hope this helps. Go out and get things in order and enjoy the rest of your life. Have a great day. Take care.